Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on today's video. On today's video, we're in session number 1 of a brand new program and a brand new series entitled Update on the QME Regulations. And this is being recorded in mid to late April 2024. And we're just learning. Sometimes it seems that we're behind the 8 ball, but as far as I'm aware, there's been no public release or public announcement. So we're just now learning that the new proposed, quote unquote, proposed QME regulations have now passed, and they've become effective retroactive to February 2024. So even though there's yet been no public announcement that the new QME regulations, or I should say the new proposed QME regulations have been adopted, we're now learning that we're learning that they actually have become adopted, and we're learning that they're adopted retroactive to February. I think it's February 21st or February 24th, 2024. So the new regulations are upon us. Lo and behold, I first started talking about the new proposed changes to the QME regulations in June of 2021. And at that time, when the new proposed QME regulations became published, I created a 6-hour program to educate all QMEs about the proposed changes. And in the time period between then, which was June 2021 and now April 2024, almost 3 years later, these proposed changes have gone through several iterations and rewritings and several public comment periods, and they're now in their final form, and they're now adopted into law. So in this program, throughout the next 6 hours that we share together, I want to share with you what are the changes that are going to impact you in your day-to-day operations as a qualified medical evaluator. And there are many, many changes that you need to be aware of. And before we get into some of those changes, I just want to emphasize to you that my understanding of the new changes to the QME regulations is that the new QME regulations are intended to improve the system that we all work in every day as qualified medical evaluators. And I want you to adopt the spirit of that in your heart, that the purpose of the new QME regulations is not to be an increased burden to us, is not to be a thorn in our side, it's not to be a cloud over our head with the imminent specter of disciplinary measures by the DWC if we're found in violation of a single of these new regulations. No. That is not the intended purpose of these new QME regulations. The intended purpose of the new QME regulations is to improve the system. And as we go through the changes, the new changes, I want to share with you how the new changes are intended to actually improve everyone's experience, from the experience of the injured worker to the experience all the way to us as qualified medical evaluators. The purpose of the new regulations is to improve the system. So I want you to embrace that as our overriding philosophy as we go through these many changes to the QME regulations. So in order to launch this program, let's actually go to the Division of Workers' Compensation's website, and let's take a look at where these QME regulations can be found for your future reference if you ever want to look up or access any of the regulations. Let's go through where to find it, how they're laid out, and actually how to navigate the QME regulations. So just as an introductory statement, and before we get into the content of today's discussion, I just want to let you know that I'm very, very excited to be a qualified medical evaluator in this day and age. It's my opinion that we're at a historic all-time best experience as qualified medical evaluators. The system has evolved with us in mind. I've been familiar and involved in many of the changes that we're going to be talking about today, and all along the way, through all the comment periods and all the participation, the overriding purpose of all discussions is to improve the experience for everyone involved, including us as qualified medical evaluators. So I'm very, very excited for myself. I'm very, very excited for you. And with that as an opening remark, let's get started on today's discussion, which is session number 1 of our new program and new series entitled Update on the QME Regulations. Okay, so here we are. We're on the Division of Workers' Compensation website, and you can see the web address clearly indicated up here in the search bar. So we're on the DWC's website. We're at the section of their website entitled Title 8 Regulations. So the QME regulations are found in California Code of Regulations, Title 8, and that's where we are here. And you'll notice that the QME regulations are found in Chapter 1 of Title 8 regulations. And the QME regulations are laid out as follows. And this is a very, very useful section. If you ever want to look something up, this section, the way that it's outlined and organized, makes it very easy for you to do research and look up. So it tells us each of the sections of the QME regulations. So here's QME Regulation 10, which is CCR, California Code of Regulation 10. 10 through 19 are found here in Article 2, and those sections deal with QME eligibility. And we'll talk about some of the sections from this particular article. And so here's how they're all laid out. And you can just read some of these topic headings. Time periods for processing applications, QME office locations. A single section discusses QME office locations. A large group of sections, 30 through 39.5, talk about how QMEs are assigned through the QME panel process. There's sections that talk about the face-to-face evaluation. There's sections 40 through 48 talk about evaluation methodology. There's minimum time guidelines for all of the various specialties of face-to-face evaluations. Sections that deal with the QME reappointment process, QME discipline process, practice parameters for the treatment of common industrial injuries, application forms, QME forms, and then there's a section here for advertising and what constitutes fraudulent or misleading advertising. So this is how it's all laid out, and throughout all of these sections of Title 1, California Code of Regulations, Title 8, there have been some changes. So there's changes in many of these regulations throughout this entirety of Chapter 1. And I want to point out to you throughout the course of our next 6 hours together, I want to point out to you the significant changes that you need to be aware of that are going to impact you in your day-to-day operations as a qualified medical evaluator. Okay, so let's take a look at exactly some of those important changes. Okay, so let's get into the topics of today's discussion. And what I want to share with you today has to deal with the major changes to the new QME regulations. And I provided this website for you that will take you directly to the QME regulations. Anytime you want to access the QME regulations, whether for research or just to look something up, this is the link that will take you directly there. And I suggest that you make a shortcut in your web browser, whatever web browser it is that you use. Create a shortcut key that simply allows you to one click gain access to the QME regulations, and this is the exact site. Now the QME regulations can be difficult to locate using standard Google search terms, so if you create a shortcut key using this exact link, it will take you directly to it every single time. So I have this as a shortcut key on all of the internet browsers that I use, and I suggest you do the same as well. So let's get into this now. We want to talk about the changes to the new QME regulations that are significant and important for you. We're not going to talk about changes that don't really impact you, but we want to talk about the ones that you need to be most concerned with and aware of. So first we'll start with some changes to the definitions of the basic terms that we use as qualified medical evaluators. And we'll talk about how the new QME regulations see these words and see these terms, and how the new regulations actually define these terms. And then we'll get into your day-to-day operations as a qualified medical evaluator. And we'll talk about, in general, we'll do a general overview of a few of the important changes that deal with scheduling appointments, how the appointments in your office are going to be scheduled from here on moving forward, at least until the next round of regulations are upon us. We'll talk about some changes to evaluation and reporting guidelines that you need to be aware of, some of which are old and some of which are new, but all of which you need to be compliant with. And then in terms of new topics, we want to talk about the new anti-bias regulations and how the new anti-bias regulations are going to affect everything about your QME practice, from your face-to-face evaluation with injured workers, to your QME reappointment process, to your QME continuing education requirements. The new anti-bias spirit, the new spirit of no bias in the workers' compensation system, is going to pervade your entire life cycle as a qualified medical evaluator. For those of you that are just now becoming qualified medical evaluators, you're going to be required to undergo anti-bias training before you can even receive your QME credential. For seasoned and existing qualified medical evaluators, you're going to be required to complete anti-bias training. And this new theme of anti-bias, or no bias, no discrimination, no stereotyping, is going to extend throughout the life cycle of all QME's careers as qualified medical evaluators. And I'll show you exactly how the Division of Workers' Compensation intends to pull this off, pull this major upheaval in our existing system, how they intend to pull it off. And then we'll talk about some new improvements for us as qualified medical evaluators dealing with electronic service of records. So if you choose to avail yourself of electronic service of records, gone will be the days of affixing postage on numerous envelopes. Gone will be the days of printing out hundreds and hundreds of pages and submitting your reports by way of snail mail. Gone will be the days of running to the post office on the 29th day in order to service your report by the 30-day deadline. And so all of those manual measures, those prohibitive and rate-limiting manual measures, are now being replaced with electronic service options, which are tremendously time and cost saving. So I'll share with you those pieces of good news. And then we'll talk about what are the circumstances and situations that the Division of Workers' Compensation can employ and utilize to deny your reappointment as a qualified medical evaluator. These are some areas that you need to be acutely aware of so that you can have a long, happy, healthy, and successful career as a qualified medical evaluator. Okay, so let's get first into CCR number 1, the very first section in Chapter 1 of Title 8 Code of Regulations, and talk about the new changes to some of the definitions of terms that we use every day in the system. Okay, so here's a list of all of the changes that are included to the new QME regulations dealing with definitions of terms. Now, not all of these are going to be important to you as a qualified medical evaluator, but we'll talk about those that are. And this is the entire list of the new changes. So new section B has to deal with some new language that describes who actually constitutes or who acts in the role of the administrative director. Section C talks about the agreed panel QME, and finally puts to rest the controversy as to when is a qualified medical evaluator chosen from the panel When is that Qualified Medical Evaluator simply the PQME? And when is that Qualified Medical Evaluator the APQME, the Agreed Panel QME? This term was unclear up until very recently with the new definition that's now provided in the new QME regulations. Section K deals with new language dealing with what constitutes a continuing education course, and this is going to apply to every single one of you who have to recertify your QME credential every 2 years and have to document that you've completed the necessary continuing education requirements. Well, those requirements have changed, and that's defined in Section K of definitions. Section O, which we won't discuss, talks about what is the role of the Disability Evaluation Unit. Maybe we'll discuss that just very briefly. Section S deals with what constitutes a re-evaluation, a new second face-to-face evaluation between you and the injured worker. That's defined newly in Section S. Section DD deals with significant financial interest of faculty, continuing education providers such as myself. So this is important language for me to understand. And for those of you who are involved in continuing education, you'll be interested in this as well. And we'll review it just for general interest of the group as well. And then finally, Section F provides some new language and some new clarity as to what constitutes a supplemental medical legal report. Both sections S and F, these deal with our obligations as qualified medical evaluators. Both of them refer us to CCR 9793 for further information about what constitutes the definition of these particular functions. And so we'll look both here at the definition as described in Title 8, and then we'll also refer to CCR 9793 to see what 9793 has to say about these terms. Okay, so let's pick these off one at a time. Let's go to the regulations, and we'll just go through these very quickly and point out the significant changes. Okay, so here we are back on the DWC's website. We're in Title 8, and let's go through the definitions, which are described here at the very beginning in section number 1 of Article 1. So that takes us to California Code of Regulation 1, the definitions. Okay, and so first thing I want to point out as we scroll down through these definitions, many of these definitions are unchanged, and I'll point out the specific ones that are changed. But what I want to draw your attention to right now is this section right here that tells us that the amendment of these sections that we're going to talk about, sections B and C, K, O, S, V, double D, and F, those were filed February 26, 2024, now become operative retroactively now to February 26, 2024. So these are new, these are active, these are the new regulations, and here are the changes. These are the new changes that have been added to law effective 2/26/2024. So let's go through these and I'll point out those of which are of significance or relevance to us as qualified medical evaluators. So here the first change has to deal with the definition of administrative director. What that term means, it means the administrative director of the DWC, State of California Department of Industrial Relations, and includes his or her or their designee. And this of course is the new language. The new language includes someone else besides the administrative director acting on behalf or under the direction of the administrative director. So that encompasses the new language right there. So not really a big deal for us as qualified medical evaluators, but I believe this is probably a big deal for the administrative director, who now can designate someone to be acting in his or her behalf. Okay, next is Section C, which talks about the Agreed Panel QME. Now, the agreed panel QME used to be a big deal. It was a big deal in the years between 2004 and 2013, and the agreed panel QME was obviated or removed in 2013, and this particular section of the new QME regulations clarifies that. Well, let's just go through it here. So the agreed panel QME means the Qualified Medical Evaluator that has been left the last evaluator standing according to the process described in the QME panel process, which is 4062.2C. This is something you need to be familiar with. This is known as the QME panel process. This is how each party strikes a name from the panel and leaves you as the last evaluator standing. So it means the Qualified Medical Evaluator that's gone through the panel process, that the claims administrator, or if none, the employer, and employer and claims administrator are generally mean the same person because it's the claims administrator that stands in the shoes of the employer. So this is the QME that the claims administrator and a represented employee, usually by way of their attorney, their applicant attorney, agree upon and select from the QME panel without using the striking process. Now, this only applies to panel lists that are issued prior to 1/1/2013. So as this is being recorded in 2014, there are no new panels that will qualify or that will be eligible for the agreed panel Qualified Medical Evaluator. But there are still some evaluations taking place for injuries prior to 1/1/13, where the medical evaluator was designated the agreed panel Qualified Medical Evaluator, and for that diminishing population of cases, the designation of agreed panel Qualified Medical Evaluator will persist. The agreed panel Qualified Medical Evaluator has now been obviated or deleted for cases after 1/1/2013, but there are still a few cases remaining which will continue to use the agreed panel QME that was assigned at the time. An agreed panel QME shall be entitled to be paid at the same rate as an agreed medical evaluator under Section 9795 for medical legal evaluation procedures and medical testimony. The provisions of this subdivision related to agreed panel QME do not apply to panel lists issued after 1/1/2013. So just a couple comments. Before the agreed panel QME was eliminated in 2013, it was a big deal to be designated the agreed panel QME. It was equivalent to being designated an AME. So it conferred a certain amount of prestige on the medical evaluator. It certainly conferred a pay raise for both the initial evaluation and then any subsequent cycles of action that were required in the case. The agreed panel Qualified Medical Evaluator got a pay bump similar to the AME, pay bump. So it was quite a big deal at the time, but it was eliminated in 2013. And this language of the new QME regulations simply clarifies what seemed to be some confusion about the agreed panel QME for dates after 1/1/2013. Okay. Also new for your future has to deal with what constitutes a continuing education course. Now, a continuing education course includes 16 hours of instruction, whereas formerly, just as early as yesterday, or I should say prior to the retroactive enactment of these new QME regulations in February 2024, the continuing education requirement forever and ever has been only 12 hours of instruction. That's now being increased to 16 hours of instruction, and we'll talk about what is the additional hours consisting of. The Division of Workers' Compensation has some very specific intent for the additional 4 hours of instruction, and we'll talk about exactly what will be included in the additional 4 hours. So a course means the 16 hours of instruction in disability evaluation report writing, which is required of a QME prior to appointment. So this deals to prior to appointment. This is not dealing with continuing education requirements, okay, which are also changing, and we'll also discuss those. But this one is specifically referring to what is currently known as the 12-hour report writing course. 12-hour report writing course is being increased to 16 hours. This is for all specialties of evaluators except chiropractors. Chiropractors have a different instruction prior to their appointment. This applies to all specialties except chiropractors. And it says that, of course, any course must be approved by the administrative director, and that makes sense. Next change has to do with Section O, which simply defines the Disability Evaluation Unit. That's the unit that's responsible for issuing the disability ratings, basically for taking the impairment ratings that we as QMEs provide and converting those impairment ratings into disability ratings. So that's Section O. Section S has some new language. It defines follow-up comprehensive medical legal evaluation. This is what we refer to as our reevaluation. These are reevaluations under the labor codes that drive the QME panel process, and the labor codes that govern the QME panel process and or the regular physician process. Regular physicians are assigned under Labor Code Section 4067, and this is going to refer us to Section 9793 of the California Code of Regulations, which we'll review in just a moment. I'll pull that up on my screen. That is Section F. Section D deals with significant financial interest for faculty such as myself, continuing education providers, disability instruction providers. So it simply requires that any continuing education or instructional provider must disclose any significant financial interest or affiliation prior to delivering their program, is basically what it says, such that the Division of Workers' Compensation and the audience is aware of any significant financial interest being held by that particular faculty. So that's important for continuing education providers such as myself. And then finally, Section F deals with supplemental medical legal evaluations, and again it refers us to 9793, and we'll go to that now. So there are two references for 9793 are here, and Section S talks about 9793G, and then the other one is 9793M. So let's pull those up, and we'll go to those right now. Okay, and this also deals with some definitions, and we'll go right to Section G, which talks about follow-up medical legal evaluation. This is an evaluation which includes an examination, so this is face-to-face, which results in the preparation of a narrative medical report prepared and attested to in accordance with Section 4628 of the Labor Code. This is the anti-ghostwriting statute here, which is attested to according to any applicable procedures under Section 139.2. This is the specified financial interests, and the requirements of Section 10682, which defines defines the template or the sections of our report and how our report is to be laid out in order to constitute a medical legal report. So this is new language. This is new language that our report must be attested to including all of these particular requirements. Next is that it's performed by a QME, AME, or a primary treating physician within 18 months following the evaluator's examination of the employee in a comprehensive medical legal evaluation. So comprehensive is the initial medical legal evaluation. The follow-up is an appointment within 18 months of the comprehensive. Within 18 months. Now, if you've performed a comprehensive medical legal evaluation and your next evaluation of the same injured worker is 19 months later, that 19 months later evaluation reverts to the comprehensive medical legal evaluation because it's outside of 18 months following your first examination in a comprehensive. Okay, do you get that little nuance? Okay, so a follow-up medical legal evaluation is within 18 months of the initial comprehensive evaluation. Anything beyond 18 months is a comprehensive medical legal evaluation. And C involves an evaluation of the same injury or injuries evaluated in the initial comprehensive medical legal evaluation. So that's our reevaluation and the definition of a reevaluation. Section M deals with the supplemental medical legal report, which this is an evaluation which does not involve a face-to-face examination of the injured worker. Okay, so this does not involve or require a face-to-face evaluation. Number 2, or B, is that it's based on the physician's review of records, it's based on test results, or it's based on other medically relevant information which was not available to the physician at the time of the initial examination. Or it could be based on a request for a factual correction pursuant to Labor Code Section 4061D. So I don't know if you know this or not, but when you're writing your report, the injured worker or any party has the opportunity to request factual corrections within the content of your report. And now, when we respond to a request for factual correction, we're able to bill that as a supplemental medical legal evaluation because it says so right here. Okay, so this is new language. C, it results in the preparation of a narrative medical report, prepared and attested to, and then here we have the same attestations that are described above for the follow-up medical legal evaluation. Exact same requirements, same topic headings and formatting as required under this particular section. This is the section, and you should look this up, that deals with what must be included in our report. What are the topics that we need to address in our report? What are the major subject headings that we need to consider in our report, etc. Those are all described in this. So this section basically tells us how we should set up our templates in order to comply, in order to expect payment actually under these billing codes for both follow-up and supplemental medical legal evaluations. And then D is performed by the QME, the AME, or the primary treating physician following the completion of a comprehensive medical legal evaluation. So those are some important things to understand about what now we need to comply with and what we need to claim and state. Well, I guess the term that is used here in the language of the law is what we need to attest to in the body of our report if we expect those reports, whether those be follow-up medical legal reports or supplemental, medical legal reports if we want those reports to be paid. Okay, so the next section that I want to discuss with you is not exactly new for the current QME regulations, now just adopted February 2024, but they are new. They're new effective February 2023. So what I want to share with you now is relatively new. These are new regulations that are just approximately now 1 year old, and have to deal with scheduling of appointments and your availability to schedule appointments within certain time periods. And these new changes, new effective February 2023, are a continuation of the COVID regulations actually. And if you remember back to that period in time during the COVID era, all of our timelines as qualified medical evaluators were relaxed quite a bit. We had more time to issue our reports, more time to schedule these reports, schedule these evaluations in the first place. And all of the timelines were relaxed due to the difficulty of getting anything done during the COVID era. Well, it was found that this particular change, this relaxed scheduling time, was beneficial to the system. It was beneficial because it resulted in fewer requests for QME replacement panels. Replacement panels, or requests for replacement panels, went down during the COVID era, and it was determined that this increased laxity or relaxed scheduling of appointments was responsible for the fewer number of requests for QME replacement panels being requested from the Division of Workers' Compensation. So it was determined that this relaxed scheduling allowance was beneficial to the system. So I'll share exactly what that is with you. And this has to do with that phone call that you get. And I know that you're familiar with this phone call. Your phone rings and it turns out to be one of the parties asking, when is Dr. Smith scheduling QME appointments in blank location? Fill in the blank, whatever satellite office location the doctor may have. When is Dr. Smith scheduling his or her next appointment in Los Angeles? You get these questions all the time, and I want to share with you what is the correct answer to that question so that, number one, you can be compliant with timelines. Number two, so that you can actually capture or secure the evaluation. And number three, so that you're not declared by the parties, meaning the parties now are declaring you, are basically reporting you as being unavailable to schedule. Even though you yourself have not declared yourself unavailable on an official basis, you're being informally declared to be unavailable by the parties when you fail to be able to schedule within certain timelines. So let's go over exactly what are these specific timelines. Okay, so scheduling of evaluations is described in section 31, 31.3, scheduling appointment with the PQME. So you'll notice that this particular section of the QME regulations has A, B, C, D, E, and F. And the amendment of subsection E and new subsection F became operative February 2023. So these regulations are now just approximately 1 year old. So let's go over subsections E and subsections F. It says, if a party with the legal right to schedule an appointment with the QME, so let's say you get a call from, the applicant attorney. It's the applicant attorney that has the legal right to schedule the appointment, and they're calling for an appointment. If that party is unable to obtain an appointment with a selected QME within 90 days of the date of the appointment request, okay, so they call your office today and they say, when is the doctor scheduling his next appointment in Santa Barbara? If that date is beyond 90 days, the party has a decision to make. If the appointment is within 90 days, let's say it's on 89 days, then the party has no decision to make. You're now declaring yourself to be an available QME, quote unquote, available QME, and there is no decision. But if the date extends beyond 90 days, that party may waive the right to a replacement panel. Okay, so let's go over this carefully. So beyond 90 days, they have the right to request a replacement panel. They have the right. So if they don't like you, if they don't want you, if they want a second bite of the apple, they can go back and they can request a replacement panel. But they have no right to request a replacement panel if you're able to schedule within 90 days of the date of the appointment request. But let's say you're booked up, you're booked solid, and between now and 90 days you just have no availability. That party may waive the right to a replacement panel in order to accept an appointment now no more than 120 days after the date of the initial request for an appointment. So the applicant attorney calls you up and you say that you're not available until 110 days. Now, that party may waive the right for a replacement panel, and they themselves singularly have the authority to extend the appointment no more than 120 days. Beyond 120 days, however, let's see what it says. If you're not available beyond 120 days, it says when the selected QME is unable to schedule the evaluation within 120 days of the date of that party's initial request for an appointment, either party. Now, either party. So the applicant attorney is the one that called you up and they said that Dr. Smith is scheduling 125 days. We're okay with it. We want to go with Dr. Smith. The other party, say the defense attorney, can say, no, this is a QME who's unavailable and I want to get a replacement panel pursuant to this section. Section 31.5 is what describes the reasons wherein a replacement panel is acceptable and appropriate. Unless, however, both parties can agree in writing to waive the 120 time day limit for scheduling the appointment. So if you're not available in less than 90 days, you run the risk of losing the evaluation. You run the risk. The party that requests you, that has the legal right, can request a replacement panel and you lose the evaluation. Now, if you're absolutely booked, that party has the sole authority to extend that time period to 120 days. But beyond 120 days, the other party can step in and say, no, enough of this. This is not reasonable. We want to select an evaluator who's available, certainly within 120 days and hopefully within 90 days. So when you get that call asking when are you available, when are you scheduling, the correct answer, if you want to eliminate the opportunity for the parties to replace you, the correct answer is I'm scheduling within 60 to 90 days, or let it be 75 to 90 days or 80 to 90 days, but always make it less than 90 days if you want to retain the evaluation, because beyond 90 days is when the great unknown kicks in and you run the risk of losing that evaluation. And then section F, which is new, says new subsection F. The provisions of subdivision E, we just read this, of this regulation apply to both requests for any comprehensive medical legal evaluation and requests for follow-up. So both your initial and your follow-ups must be within 90 days for all of the reasons that we just discussed. Okay, so schedule your appointments soon, certainly within 90 days, and even between 60 and 90 days. If you can accommodate that, and you're available between 60 and 90 days. The purpose of these requirements are to keep the system moving and keep evaluators from scheduling appointments 6 months, 9 months, a year out into the future. The purpose is to keep the system moving. So help the system to keep moving by making yourself available within 90 days. Okay, and then some of the other interesting changes to the QME regulations that we're going to be focusing on throughout the remainder of this program together have to deal with some of the following. So for example, in California Code of Regulations 35.5, which talks about the evaluation and reporting guidelines, there's at least 2 significant changes that I want to discuss with you, and there's also some substantial existing language already contained within that section of the law, which I want to reiterate and re-emphasize and maybe reacquaint you with as we go over this in one of our subsequent sessions. But what's new for the new QME regulations, meaning just adopted in February 2024, are 2 sections. Number one which has to deal with issues that are outside of your scope of expertise of the particular specialty that you're evaluating in. So for example, I myself am a chiropractor, and if I run across any issues that are outside of my scope of practice or expertise as a chiropractor, there are certain procedures that I must go through and comply with in order to illuminate for the parties these issues. In other words, in order to declare and expose these issues and to get these issues handled by the appropriate specialists, new sections in 35.5 tell us what are our obligations when we do encounter those situations where there are issues outside of our scope of specialty or outside of our scope of expertise. So that's number one of the important changes in 35.5. Also, brand new language in 35.5 is part of the anti-bias sections of regulations, and it has to deal with a new disclosure that we're required to add to the disclosures at the very end of our report. And this new disclosure has to deal with attesting that we have not discriminated against any of the parties involved in the evaluation, and the language is specific to all the parties of the evaluation, not just the injured worker. And I'll be sharing with you that exact language when we get to this discussion. Also, there's a specific language in 35.5 that I want to reacquaint you with about what is required of us in issuing our reports. You know, the purpose of our reports is to resolve disputed issues, and we learn of those issues in dispute in the cover letters that are sent to us by the parties. Well, the parties notify us of the issues in dispute and notify us what they need from us in the questions that they provide in the cover letters that they send to us. So the purpose of hiring you as the Qualified Medical Evaluator is for you to answer some unanswered questions. The parties have some questions to which they need answers to, and they look to us, they look to you as the Qualified Medical Evaluator for those answers, and they give you the questions to which they need answers to in the cover letters that they send to you. So section 35.5 tells us exactly what we need to do to please the parties, to satisfy the parties, to scratch the itch of the parties, and how it is that we address the questions that they send to us in their issue cover letters. So we'll talk about that in great detail in a subsequent session. And then also, just very briefly, when you are the first evaluator, to whether you know, if the primary treating physician has not yet done this, if any other evaluator has not done this, if you are the first evaluator to declare the examinee to be permanent and stationary, you have an obligation to fill out a certain form, the return to work form, the physician's return to work status form. And not many qualified medical evaluators actually comply with this. And that throws a monkey wrench into the spokes of the system and tremendously slows down the system, especially in those cases that are nearing resolution. Okay, so if we think about this, this is now at a point where the examinee is being declared permanent and stationary. The claim is coming to a resolution. It's coming to a close. And at this point, in order to fully close the case, one of the steps that's required is that you as the physician provide the parties with your opinion, your statement as to what is the return to work status of this particular employee or injured worker. And I want to reemphasize the necessity and the importance of completing this form, and we'll go over that in great detail in our very next session. Now, next is probably the most significant change, bar none, of the new QME regulations. And this has to do with several sections that contain new language that deal with anti-bias, removing discrimination, removing stereotyping, and encouraging us as qualified medical evaluators to provide opinions and conclusions that are accurate. And by accurate, what the intention is that our opinions and conclusions, especially with regards to impairment ratings and our apportionment determinations, are free from bias, are free from stereotyping, and that are accurate without all of the overlay of our inherent and implicit stereotypes and inherent and implicit biases and all of these things that cloud our judgment and cause us to render opinions and conclusions that are not accurate, okay? And so this is a fascinating era that we're now entering into. We're all entering in this together at the same time, collectively as a group, and it's going to be very, very fascinating to see what evolves from this. And I myself am very keen about my own evaluations and ensuring, to the extent possible, and I admit that I'm only human just like you, but to the extent possible, I'm trying to be more accurate, to be more objective, and to eliminate bias from my opinions and conclusions. So there's several sections, both old and new, that deal with this issue. So for example, and we're going to review this, we're going to review section 40, which deals with the disclosure requirements. This is not new, but this is one of the first earliest regulations that dealt with bias, particularly in our face-to-face evaluation, but also deals with bias in general throughout the entirety of our evaluation. New CCR 35.5H, we just referred to this in our last slide. We talked about having a new attestation in the disclosure section of our reports, where we attest to the parties that indeed we did not discriminate in any way. And this is sort of our final self-check before we put our signature on the report, that our report is free and clear of the cloud of bias in any of our opinions or conclusions. Section 5110, which we'll go over, contains new language about anti-bias and anti-bias training. And then CCR 55 describes the continuing education requirements from here on out, from here into forever land. All continuing education programs along the life cycle of the QME are going to contain specific instruction about bias and about how to eliminate bias in the medical legal evaluation. So we're going to go over this section of the new regulations in painstaking detail so that you can capture the spirit of the intention of these new regulations, and so that with your very next evaluation, because these are now adopted into law, this applies to your very next evaluation. Your very next evaluation is going to be conducted by a completely different a completely different evaluator, a completely more objective evaluator than you've ever been in the past. And so the purpose of these new regulations is to improve you as an evaluator. These are directed at you, at me, at all of us, specifically directed at the QME. So we're going to go over these in painstaking detail. And then finally, the sections that I want to share with you have to deal with convenience and ease for us as qualified medical evaluators. Particularly, I'm referring to not a brand new section of the new QME regulations, but relatively new, meaning adopted 4/12/2022 in response to the COVID regulations, has to deal with electronic service of records. And I'll share with you this language. This may be helpful for many of you, most of you, who are still submitting your reports the old-fashioned way with paper, envelopes, stamps, and postage. And this new electronic service of records, I've done calculations on this, and I've been able to demonstrate that electronic service of records can save as much as $20 on the administrative cost per report, per evaluation. When you consider printing costs, postage costs, that doesn't even include time costs of taking these envelopes to the mailbox or the post office, and doesn't even cover costs if you're the type of evaluator that submits your reports by way of certified return receipt request. Just basic postage and paper and printing costs can save as many as $20 per evaluation. So over time, just considering the cost over time, this could be a substantial cost savings to you in terms of your overhead of producing these evaluations. Not only that, it's extremely time efficient as well to submit these reports electronically, because it eliminates all of the manual processing of these reports. So I'll share with you what constitutes electronic service and some of the language that you have to comply with if you choose to submit your reports electronically under Section 36.7. And then finally, we're going to spend some great time on CCR 51, which does contain some brand new language effective now February 2024. And it talks about those situations and circumstances where the Division of Workers' Compensation can deny your reappointment request as a qualified medical evaluator. Now, let me tell you this, that the only reasons that the Division of Workers' Compensation would deny a qualified medical evaluator's reappointment in an era when we do not have enough qualified medical evaluators, okay? There's only a few reasons that they would deny your reappointment, and those reasons have to do with you being a pain, a backlog, a problem, a blockage, a barrier, a rate-limiting step to the system. It's when you're being a problem on the system, a burden on the system, that the Division of Workers' Compensation finds ways to have you eliminated from the system. And this section, CCR 51, talks about the finite list. It's not infinite. It's a finite list of reasons whereby the Division of Workers' Compensation simply comes to the conclusion that you're more trouble than you are help to the system. And we'll go over each and every one of these in painstaking detail so that you can find yourself never under the Division of Workers' Compensation scrutiny, and so that you can go on and enjoy a long, happy, healthy career as a qualified medical evaluator, free from any disciplinary action by the Division of Workers' Compensation. So this is an introductory video to describe some of what we're going to get into in more detail in our subsequent sessions. I want you to know that I'm very, very excited to share these new regulations with you. They've been a long time coming, and there's been much buzz about these new regulations. Again, the whole purpose of these new regulations is to improve the system. And I'm sure that you will conclude that yourself as well as we go through each and every one of these sections in painstaking detail. And I'll share with you exactly how these regulations will play out or manifest in actual day-to-day operations, in the actual face-to-face evaluation, in the actual writing of your reports, in the actual submission of your reports, so that you yourself can conclude that indeed these new QME regulations do indeed intend to improve the system for all of us. So look forward to being with you on our very next session as we begin this brand new program, which is entitled Update on the QME Regulations. For now, this is Dr. Perry Carpenter. I'm wishing you best of success in your career as a Qualified Medical Evaluator.